Cast is now starting. All attendees are in listen-only mode.
Okay. All right, so welcome to the webinar, everyone. My name is Margaret Henn. I am the Director of Program Management here at MVLS, and this webinar is called Staying Afloat, Assisting Tenants with Water Bills, and we are going to focus on issues that affect tenants in Baltimore City with water bills primarily. Currently, as you may or may not be aware, well, actually, I'll say there was a very recent change to the law in Baltimore City regarding water bills. So we're going to talk a little bit about this. But prior to the new law, tenants could not be account holders on the water bill, and they therefore often did not have access to their water bills or their water bill history, and they couldn't dispute the bills or request adjustments without their landlord's involvement. These barriers open the door wide to potential abuse by landlords, which sometimes manifested in eviction proceedings or post-move-out collection actions. And so we're going to talk about those things as well. So we are very excited to have with us here today Zephyr Shah from the Public Justice Center and Louise Carwell from Maryland Legal Aid, who are going to join us to discuss this important issue, talk to you about strategies for helping tenants, and what we can do to make positive change in this area. So I do want to remind everyone that there are some materials, and they should be in the handout section of your GoToWebinar. So you should see a little thing along the side of your screen that says handouts, and you will have a link to the PowerPoint that we're about to present. We are going to also at the end of the presentation take some questions, so you will have the opportunity to type your questions into the chat box on GoToWebinar. You will be muted during the webinar, but please type in any questions that you have. I'll collect them as we go, and we will definitely be glad to answer questions at the end of the webinar. This webinar is going to be recorded and it'll be available on our website. So if you want to reference back to anything after the fact, or if you have other colleagues that you want to refer to watch the webinar, we would definitely be happy to have people do that after today. So I'm going to, with that, introduce our presenters. Louise Carwell is a senior staff attorney at Maryland Legal Aid. She has over 34 years of experience handling a wide array of consumer, housing, and bankruptcy cases. Zephyr Shah is an attorney in the Human Right to Housing Project at the Public Justice Center, and he provides direct client services as well as working on impact litigation and legislative advocacy there. So we will start with Zephyr talking about some rent court and district court issues, I believe, and then Louise will address some issues regarding Chapter 7 bankruptcy. We'll also talk about the Water Affordability and Equity Act, as well as how clients can access water discount programs right now. So with that, again, please let me know if you have any questions or any technical issues regarding the webinar, and we will go ahead and jump into the presentation. So, Zephyr, Louise.
Yeah, so actually we've organized the slides to start with what is the overview of current law, as well as the kind of softer area of what programs DPW is providing to tenants, at least in nominally. And so I think the first legal issue that every attorney needs to understand when advocating for a tenant with the Department of Public Works is that the department has an almost religious belief that tenants are not customers. DPW has no statutory-based relationship with the tenant. They will constantly tell you, and this is actually in Article 24 of the City Code, that the ultimate responsibility for payment of a water and sewer bill lies with the owner of the property, who is the account holder and therefore the customer with DPW. And so whatever happens, from the department's point of view, whatever's happening between a landlord and tenant with a water bill is sort of a contractual assignment. It's a private contractual relationship between the actual user of the water, which is the tenant, and the account holder, and DPW will have nothing to do with it. And that is kind of the guiding approach that the department has had for many, many years, which is very problematic for our clients, and kind of has come out not only legislatively, but in just day-to-day practice of law, like a tenant trying to get access to documents that will help them understand what amount of money they owe or what's happening with the account. In 2018, a little bill that came out of a tax sale foreclosure work group in Annapolis was passed, and it's the only state provision that really applies to Baltimore City tenants at the moment, in the sense of how water bills, how the obligation for a tenant to pay water bills is set forth. And so Real Property Article 8-205.1 states that where the property is a 1 or 2 unit residential property, the landlord, to obligate the tenant to pay the water bill, has to use a written lease that specifies that obligation, and that the landlord must also provide a copy of the water bill to that tenant. And this is only for the obligation to reimburse the landlord. It's such a sort of subsection of all scenarios that this is actually very little known at this point and little applied. But basically, if the tenant is to be obligated to reimburse the landlord for the landlord's payment of the water bill, this applies. And notably, tenants in multifamily properties, tenants who are told to pay to DPW directly, they're not included in this provision, which is ultimately all about whether the tenant has access to the copy of the water bill. A very crucial part of advocacy for the tenant is to know what beyond just the dollar amount does your client know about the water bill. Next slide. So the Department of Public Works website has undergone a lot of improvements, and it's still not a very helpful website. But you'll see that the number of different programs that the department provides right now can be a little confusing. Some of these overlap. So for instance, the low-income water bill assistance program overlaps with the BH2O billing assistance program. BH2O actually has 2 different variants. There's the Baltimore H2O billing assistance, and then there's BH2O plus, depending on your income level. The low-income water bill assistance program probably in practice doesn't exist anymore. When my clients go down to DPW, they're told they can't apply for that. It's actually a payment plan program, as far as I understand now. Although you see for the different links, there's a different link for the payment plan program. Right now, to apply for H2O or H2O assist, most people go down to DPW. They're actually right now being turned away at the DPW office on Holiday Street and being told that they can only do the application and turn in the application at a Center for Community Action Center. So that's another important thing. I've mistakenly sent people down to DPW, but you have to go to the CAP.
Have you all had success with people who do go to the CAP centers in getting the discount?
So sometimes we have, our office has, and I don't suggest that everyone has to do this, but when we have someone who has a problem, we will directly help them to do it and directly send it. And step it up
Mhm.
with personnel if we're not able to get it approved.
Mhm.
So I will say that.
When you say directly send it, you mean you would, as their attorney, would directly send it to DPW?
Correct.
Not
And
the
we'll,
CAP Center.
and correct. And then we'll CC it to somebody that we have a relationship at DPW to make sure it gets taken care of, or someone at the mayor's office, for example, only because it's difficult for an individual client, especially if they're elderly or they work and they can't always be keeping up with this paperwork to make sure it gets taken care of. So you may need to just give it a little extra push to make sure that you're able to track it. I won't say that's true all the time. I think it's improved, but that may be the case.
Yeah, and I'll just mention quickly for volunteer attorneys who take these cases through MVLS, we would be happy to answer questions, provide the correct contacts at DPW or the mayor's office to try to facilitate getting your cases worked out as well. So just reach out to MVLS if you're having any issues with that. So I'll let you guys get back into it.
Yeah, so the fundamental problem with the discount programs right now and any kind of account services that go on at DPW is that frontline staff must ask a tenant to provide basically the permission they have from the landlord to conduct any, application process or dispute resolution process. The tenant has to get that permission from the landlord. It takes the landlord to participate, and that, in some senses, is the end of the road for the tenant because they have an out-of-town landlord or they have a property management company that is not interested in dealing with the issue. I've had clients who showed me a text message after I advised them on what to do, and the text message is from the landlord saying, "This is your problem. Take care of it." There is a good faith responsibility of the landlord to help a tenant in this situation, but certainly nothing in statute, nothing in the standards of protocol at DPW. The application for H2O Assist right now says an applicant must be a resident who receives and is responsible for the water and sewer bill. And that's issued directly to them in their name. And so that eligibility criteria is a real gatekeeper. Very few of my clients have gotten through that. So that's why we worked so hard on the Water Affordability and Equity Act, which was passed in City Council in November after more than 2 years of advocacy by a very broad range of advocates and activists. This included MVLS, PBRC, Public Justice Center, Homeless Representation Project. Just everybody was on board for this. And we got it passed. It was signed this week by the mayor. It'll be effective in the middle of the summer. Well, a lot of folks are on vacation. But basically the WAEA sets up three components that will help tenants with water bills. The first is probably the most important, the Water for All discount program. This streamlines and expands discounts at DPW, puts them into statute to increase the affordability, and we'll go into what the model is in a minute. But the other important piece of this is the Office of Water Customer Advocacy and Appeals to administer a comprehensive and fair process for all customers, all consumers, to do a number of things. So contesting bills, cut off liens, and other agency decisions. And then this office will also facilitate reporting to City Council on kind of the macro level trends in accuracy of water bills and other aspects of provision of water sewer services. So the change is coming. There's quite a lot of change. This will affect homeowners certainly we've highlighted some of the ways that tenants will be affected directly by the legislation. So the first one is that tenants will be defined as a customer of the department. And we kind of threaded the needle here to get that customer definition while also leaving the premise-based billing system that the department uses. So in that sense, the landlord is still ultimately responsible for what happens with the bill. But as defined as a customer, tenants have the statutory right, beginning in July, to participate in whatever is the applicable discount program for them, plus the bill dispute resolution and appeals process. So the statute is all about direct access for tenants, no matter what type of property they're in, whether they pay directly to DPW or to as reimbursement to the landlord. They will have rights such as having the right to a written lease that describes their obligation to pay for the water sewer cost. They'll have the right to be designated as a designee under the Maryland Public Information Act, so that they can directly request and receive any account record from Department of Public Works about the meter for the water sewer service. That goes for both, a tenant in a single family home as well as tenants in a multifamily property with the master meter. So, excuse me, the landlord has to timely provide a copy of the water bill or timely ensure that DPW is sending the bill directly to the tenant. And so for master metered multifamily properties, these are the kinds that use a RUBS or ratio utility billing system. The lease for those units has to describe the calculation method that the landlord is using for allocation of charges, and also demonstrate the average monthly cost for that unit's water and sewer service over the 12 months prior to the execution of renewal of the lease. This is just an important transparency mechanism so that tenants will be able to know what they're getting into exactly before they move into one of those master metered properties.
I just want to congratulate everyone who worked on the language around this bill and moving it forward, because this really is a massive change for tenants in their ability to interact with DPW and take advantage of dispute processes and discount programs. So congratulations.
Margaret was in a lot of those meetings.
Well, congratulate myself.
So for the curious and forward-looking, this slide explains how the waterfall discount program operates. You see that it's tiered and based on household income, and it targets the households with an income of 0 to 200% of the federal poverty line. And you can see how that breaks down. But one of the lesser known facets of this legislation, and one of the major improvements over the existing Baltimore H2O Assist, H2O Plus, is the way that enrollment in the waterfall discount program will affect existing debt that the tenant has on their water bill. So recipients of the credit, the waterfall credit, will not have to pay additional fees and interest or catch-up payments on their pre-existing water debt while enrolled in the program. And then there's sort of a double counting of what payments they are making with the credit. So each on-time complete payment made by a recipient is also credited towards their pre-enrollment water debt in the amount of that payment until all water debt is paid off. And so this is facilitating not only payment of forthcoming bills, but then also erasing whatever the arrears is on the account. And this is the formula. You'll find it in the statute once it's put into the books, but I just thought I'd include that
Yeah, that's helpful.
People who love detail.
People who like math.
Okay, and Lisa, I don't know if you want to jump in at any point, but this slide explains a much more robust dispute resolution process than the city has ever had for water bill disputes. Many will remember the informal hearings. Now we have an actual tiered system of review and the pathways for appeal for the tenant, as well as, the homeowners. So tenants have this direct access now to seek assistance from a customer advocate. They can submit a written request, but importantly for folks with disability or other impediments in their life, they can make an oral request to a customer advocate on the phone within 90 days of a department action or decision that relates to the discount or the bill or cutoff and so forth. A customer advocate can provide only certain types of relief, and those are mainly going to be changing the amount due for a bill or reversing some other agency decision. That might be like a decision to cut off service or a decision that someone's not eligible for the discount program. But what we envision in this, and it didn't come out in the specific language of the bill, is refunds of bills. I mean, those have to come from the Department of Finance, and that's why DPW is only obligated to change the amount of the amount of the bill due at a certain time. The customer advocate will release an investigative report. I mean, it's important to understand that this is someone who works at DPW, but is supposed to be insulated from other supervision so that they can do an independent investigation. But the tenant can appeal from the decision of the customer advocate, and that appeal would be conducted by a hearing officer of the Environmental Citation Board. And there, in that forum, the customer, the tenant, can cross-examine DPW. They can provide their own evidence. It's a fully fledged type of mechanism to contest an agency decision. One of the areas of the forthcoming law that we probably need to change is the actual independence of the hearing officer at ECB. Their decision has to be reviewed by the DPW director ultimately. But if there's an unsatisfactory decision at that highest level, then the law does spell out a judicial review in the circuit court. We know it's a very long process. Not everyone's going to be able to do it because they don't have an attorney. But luckily, there's still a lot of momentum behind seeing changes to the existing bill dispute process. There's just certain steps that have to be taken to ensure independence.
If I can just jump in here. So in meetings with when the ECB was undertaking this, and I know from the other types of disputes that come before them, the notion is that those hearings are, in a sense, rather informal, trying to get to a resolution. So in theory, a tenant should be able to sit down comfortably and have this talked out. So it's not a hearing as you would think an administrative hearing or a trial in the district court or the rent court. And that's both good and bad, I think, as an attorney. If you accompany a tenant, you may find it helpful in a mediation sense. If you're a litigator, you may not find it helpful because it is a little bit, there are no formal rules. So that's just something to keep in mind. And I do have a concern that when it goes up to the DPW director and then for judicial review, that the record underneath is not going to be especially clear. And that's going to be hard for a circuit court judge to make a decision. So I think going forward, we really need to look at that and make some good suggestions so that it will be a process that can end up helping the tenant who may at the beginning not be keeping records, not be keeping bills, and then going forward they go to the circuit court and all of that is missing and the court just doesn't have a good record to make a decision on.
Yeah, I think all of those things are really good points, and I'm sure that it's going to take some legal services advocates and pro bono attorneys handling some of these issues under the new regulations and kind of working through these to potentially see what needs to be tweaked in the future.
So I'm going to talk a little bit about bankruptcy. Before I do that, I just want to mention a couple things. One is that this issue is really important because ultimately it can lead to tenants losing their housing. If you have a tenant who has a housing choice voucher or Section 8 voucher, if they have a bill that a landlord is claiming they owe, they can lose their voucher, and those vouchers are extremely valuable, so they lose that assistance with subsidized housing. If a landlord decides to sue them for a water bill later on after they've moved out, it can lead to the judicial collection activities such as garnishments of wages if they're working or levies on their bank account. The other thing just to be knowledgeable about and to have a little bit of perspective, if you don't, water bills have gone up in Baltimore City 10% for the last 8 years. We don't see an end in sight. And that is for the most part due to the city of Baltimore having this decades-old water system, and it leads to horrible water pollution flowing into eventually the bay. And so the federal Department of Environment has Baltimore City under this extended consent degree, and so Baltimore has to fix its pipes, but all the costs are being borne by its tenants and its property owners. And another just item I want to point out, sort of in a hodgepodge of things, is that from time to time you may see tenants that have water bills from before they even moved into the property. So you may have to uncover that, and tenants are not realizing that until later or may never realize it. So it's just something to keep in mind, because trying to get water bills from the water department that are not your clients and that the landlord refuses to turn over is going to require a subpoena from DPW. So having said that, then just moving forward to bankruptcy, our office does often, especially with our Section 8 tenants, consider a Chapter 7 bankruptcy if, in fact, it's going to protect a tenant's voucher or stop a wage garnishment. The reason that this can be helpful is it will automatically stop any collection action from going forward, and water bills will be discharged in bankruptcy. It may seem like an extreme measure, but I think that especially with our Section 8 tenants, the value of the voucher is incredibly large. Sometimes you really can't calculate it, and so to be able to keep someone in the Section 8 program by discharging a large water bill, and water bills can be in the hundreds, but they can also be in the thousands. And your client may also have other bills that can be discharged that will be helpful with them moving forward. A tenant who has filed a Chapter 7 bankruptcy in the last 8 years and received a discharge may not be eligible for a Chapter 7. I know that some of you may not do any bankruptcy law, but you may want to at least think about it as a measure for the person in front of you, and then determine maybe there is someone that can help them with that. Certainly, many Maryland Legal Aid and other legal services providers in Baltimore do assist individuals with filing bankruptcy if they can't afford to hire an attorney. So I urge that. The other measure that bankruptcy is helpful with is that a housing authority that will hold hearings if in fact the tenant does owe money on their bill is prohibited from going forward in those hearings once the bankruptcy is filed. Those are all violations of the stay, and the loss of a Section 8 benefit is also stayed. So I think that it's certainly a different approach that we are forced to use often, especially when tenants have come to a point where they either should have paid the bill and just never did, or it's too long past our ability to sort of roll back a judgment that's been entered or a landlord's attempt to collect on a bill.
So lastly, we're talking about water bills and eviction cases. And this nexus occurs really in two different types of eviction case, the main one being the failure to pay rent, a summary ejectment action, where water is alleged to be part of the rent or additional rent. And the other type of action is a breach of lease action, where the allegation is that the tenant breached the lease by failing to pay the water bill. In the failure to pay rent context, there's been some interesting changes in the past couple of years that are not uniform, but certainly in Baltimore City District Court might appear that way to a landlord or to a tenant. And that's because of the Lockett Blue Ocean versus Blue Ocean case from 2016, which for the first time is the Court of Appeals defining what rent means in a residential lease context. And it's not the arguments about what is rent and what's not, what can be included in rent, what can't be, is not a new issue from 2016. It goes back to the late 1970s in our case law. But all cases in between were about commercial leases. And so that's why there's a tremendous amount of debate about what actually happens in a residential context, what's allowed to happen. So to begin with, most residential leases that clients have include language that obligates the tenant to pay the utility bills for the property, including the water bill. And will state that if the tenant fails to pay, the landlord may then step in and pay on behalf of the tenant. And those payments made on behalf of the tenant would be deemed as rent or added rent or additional rent. And this language is in most residential leases so that the landlord then has some facial basis to go to the summary ejectment process, the failure to pay rent docket, and say that they can collect those charges as rent. Because summary ejectment is this very limited proceeding, very rapid proceeding, where ostensibly the court is only determining whether rent, late fees, and other court costs might be due and unpaid. So they're shoehorning other stuff into the meaning of rent. And that often is water, because tenants can't, up till now, couldn't set up their own account. They still won't be able to set up an account under the Water Affordability and Equity Act, but they will have more direct access to account services. So while it's clearly permitted to do this kind of shoehorning in the commercial context, in the residential context, it's been left to be a case-by-case determination in court. But case-by-case determinations just don't happen in rent court. And so as a custom in district courts, for many decades, we've just had very little inspection unless there was an attorney involved advocating for the tenant about whether the shoehorning language was actually for a readily ascertainable amount, whether that amount went to the usage on the premise, and whether there was fair bargaining power between parties. These are factors that the Court of Appeals said in 1978, I believe, a court would have to look at on a case-by-case basis. And then with the Lockett case, this custom of allowing any inclusions into the rent complaint was really disrupted. Today, it's been like 3 years, 2 years. Most judges on the district court at the outset of a rent case will tell the gallery they don't include other charges as rent. There are some outliers who will say, well, if it's allowed in the lease, I'm going to allow it. By and large, though, it's almost uniform that there's the adoption of the Lockett definition of rent that excludes water bills especially. But at the same time, most judges will allow that a landlord has taken the most recent rent payment and allocated it to the oldest charges on the account. And so there's that kind of workaround in effect where if those oldest charges were water bills, then the tenant is left with an arrears on their rent. And the judges may not be carefully reviewing in those cases that the alleged rent is actually after deductions for non-rent amounts such as the water bill. Now, in the federally subsidized context, there's typically language in leases against this type of misallocation. There's also the Sager versus Housing case, which suggested that that kind of allocation of rent to a non-rent charge is predatory and against the law. So, that's a different context, and most of this is about the market context. I would expect that with the WAEA in effect later this year, more landlords will be attempting to get the tenant's name on the bill so that there's a more direct relationship, and that would hopefully circumvent the need to have to go to rent court. But the truth is that the rent court process in Baltimore City takes about 12 days between filing a judgment, which is much faster than having to deal with the Department of Public Works. So there's that perverse incentive to just deal with these problems under threat of eviction. Now, the other case context is the breach of lease context. As an advocate, I'm usually kind of hinting to the landlords, hey, why don't you just take care of this in breach of lease or in small claims rather than through failure to pay. But in the breach of lease context, the landlord has a higher burden to show that failure to pay the water bill was not just a violation of the lease, but a substantial violation that warrants eviction. And that's ultimately a judgment call of the judge. There's no express right to cure this type of violation under our breach of lease statute. And that might exist in a federal subsidy lease. But what I've seen in practice is that if a tenant can put on evidence that they resorted to the assistance of Department of Public Works to adjust a bill that they haven't paid, that will sometimes be enough for the judge to find that the violation was not substantial. Now, if someone was thwarted in their attempt to get that assistance from DPW, it could work the other way, where because there was no payment, there was a threat of a lien or a threat of cutoff, the judge is finding that it's a substantial enough violation because it could put somebody, the tenant or the landlord, in some type of jeopardy, and that is the basis for awarding the eviction. I would hope, again, with the Water Affordability and Equity Act, that because there's more direct access to dispute resolution. And because the dispute resolution process itself will put a stay on any type of cutoff by DPW, this will, again, help tenants avoid eviction in the breach of lease context.
All right. So, do either of you have anything else to add? I think I'm going to open it up to questions, but I don't want to cut it off if you have some other points to add. Okay, so that brings us to the end of the slideshow, but we definitely want to open it up for questions from the audience. I know I have a couple questions, so what I'm going to do is give folks some time, if you do have questions, to type them into the chat box while I go through a couple of pieces of information about volunteer cases. So if you have questions while I'm talking, please feel free to type them into the chat box, and we will get to those in just a moment. First of all, I just wanted to, again, thank our presenters very much for this presentation. Those of you who have taken a volunteer case in the landlord-tenant arena or tax sale arena, utility bill arena, foreclosure, a number of types of cases MVLS handles often intersect with water bills. So you've probably seen this issue come up. It's incredibly relevant to our clients. It obviously impacts their ability to stay in their homes and puts them at risk of potential homelessness if they can't resolve it. So this is an issue that cuts across so many of the areas that MVLS helps clients with. So really important information that was shared today. I do want to remind folks who are on the webinar that MVLS does provide access to malpractice insurance for our volunteers and mentors. And also I just wanted to remind folks about our pro bono portal, which is what you're seeing up on your screen right now on our website. So the pro bono portal is an online way that you can get your volunteer cases. This is I apologize, this isn't the clearest picture, but that's kind of what the portal looks like. You'll see little colorful boxes with different case types, and you can just go on there and tell us that you're interested in a case, and one of our paralegals will follow up with you to talk to you more about the case and get you more information. So I encourage people to check out our portal for available cases. I do want to let everybody know that this webinar is part of our third Thursday training series. We do a webinar on the third Thursday of every month at 12 o'clock. Next month's third Thursday webinar is about uncontested adoption in Maryland, and we welcome anyone to participate in that. We also, the other webinar that's listed up here is we have a tax-related webinar for our low-income tax controversy project almost every month, and so we're having one in February, and we would welcome folks to attend that as well. For any of our past trainings, as I mentioned earlier, many of them are available on our website. Please do visit our website to take any of the trainings. We have them in pretty much every area we have cases in. This slide lists consumer, estate planning, expungement, family law, housing, human trafficking prevention, tax, and a number of other kind of soft skill trainings in that might be helpful to you in your law practice. So please check out our trainings on our website, and we hope that you will be able to join us again. I think I don't see any questions yet, but I actually have a couple questions that I thought of while we were talking. So one of the questions was that, Louise, you had mentioned clients who had a water bill before they moved into a property. If someone came to you in that situation, what, if anything, could they, could they do about it, or would you advise them to do in that type of a situation?
So just to be clear, it's a tenant whose landlord is saying you owe X, and the tenant is able to find out, or the advocate is able to find out that that water bill accrued prior to the tenant ever taking possession of the property.
Yes, that's the type of the situation I was thinking.
So certainly if they're sued in the district court, you would want to subpoena DPW or get copies, if you could in another way, to show that in fact that bill did not relate to the tenancy of your tenant, to be able to get that portion taken care of or reduced, the amount that they're being sued for reduced. And sometimes you have landlords that if you simply are able to bring that, the fact that you know that to their attention, they will agree to reduce the bill. So that's how it comes up. And if you have a tenant who has been sued in small claims and they come to you after the fact and a large portion of their bill was not theirs, they're still within their 30-day appeal period, could certainly appeal. They will have a whole new trial at the circuit court level, and you could do it that way.
Great, thank you. So what, if any, advice do either of you have? I know we've talked a lot about this new law that's coming into effect, and it will be in effect in July, but for a customer that has a past water bill issue, I know unfortunately this is something that comes up pretty often, someone who may have an issue that's been going on for months or even a year or more that they haven't been able to resolve with DPW, and now they're coming into your office. Do you have any insights about folks in those types of situations?
So I have that situation right now with a homeowner, actually. I have reached out to DPW and CC, I think 9 other people. So one of the bills is actually more than a year old. The DPW often will keep to the position that if it's more than a year old, it is what it is. So I'm looking into some ways to possibly, if we can't resolve it, although sometimes we're able to, seeing if there is some kind of hook that we may be able to file a court action against DPW for that, because, for example, this gentleman is a truck driver. He drives all across the country. He does not have time to be constantly going downtown because he's not in the state, and trying to figure out why during certain months his water bill just was huge, and it's obvious from his bill. Also possibly doing public information request to see if there was work that was being done on his street during certain parts of the year, and maybe all the individuals on his street were affected that way, and that's simply not being acknowledged by the Department of Public Works. That's just a couple ideas I have.
Yeah, I frequently will hear people say, you know, I've talked to my neighbors about this issue, and a lot of people on the block or the street had a certain issue with DPW in a period of time. I know that's something that I've definitely heard come up.
And for tenants whose landlord jumps in and pays the water bill, this is one of the conundrums that we'll face even with the Water Flow Bill and Equity Act, because the avenues that are being opened up to pay down a debt to DPW and get a lower, more affordable rate aren't going to matter if the landlord isn't participating, is actually by swift payment of excessive or just unaffordable bills, forcing the tenant to just pay back to the landlord rather than to the Department of Public Works. And so it's really a point of just education for landlords and showing them what the incentives are. Right now, I really don't understand why some companies, property management companies especially, pay obviously excessive water bills and then try to seek swift reimbursement through eviction. That's for the landlords to explain, but I'm optimistic that with the changes that there will be some industry groups or whoever else letting landlords know, homeowners basically, know that they can make that bill more affordable through proactively assisting tenants and educating tenants to go and use discount program so that that landlord company doesn't have to front the cost for the bills.
Yeah, and I mean, you think it would, vastly lower the bills that are coming in every month, which potentially should help the landlord if at any time they were to get behind also. So yeah, hopefully they will start taking advantage of that. So one other question that I thought of is often we will see clients who are actually technically not a homeowner or a tenant, and by that I mean it may be like an heir property situation where the person who lives there is not on the deed, maybe a grandmother or past family member was the one who was on the deed and is now deceased. For people in those situations, what, if any, access will they have to these new processes through DPW, or how would you potentially advise someone in that type of a situation?
So I would think possibly if they could open an estate and be named personal representative, that may give them some authority. It does with the state's homeowners property tax credit office. So possibly that could give you a little bit of a hook. That's just one suggestion I have.
Yeah,
they may not want to do that, and I understand that, but it may give them some legal authority because they are, I think, they have an argument that they are responsible for the estate and protecting the estate from DPW, which is a creditor.
Yeah, no, I think it's a good suggestion. I don't know that there's any easy answer to that question. I just know that that is, we have on our intake form, for instance, are you a homeowner or do you rent? And some people actually don't fit into either of those categories. So that can just add one extra layer of challenge to working through these situations. So I think that kind of, I don't think I see any other questions. I'm going to check one more time, but I do want to, again, thank our presenters so much for doing this presentation. I thought it was incredibly helpful, and maybe next year we'll have to have a follow-up, at this time to see how things are going, as this bill has been in effect for, 6 or 7 months. But thank you for being here. Thanks to our attendees for being on the webinar. This was a great presentation.
Thank you.
So with that, I'm going to go ahead and conclude the webinar.